வானத்தை வில்லா வளைச்சிடுறேன், மணலை கயிறா திரிச்சிடுறேன், லாட்டின் வேர்ட்ஸ் எல்லாம் போட்டு அப்புறம் வந்து யுபிஜஸ் இபி ரெமிடியம் உப்ரிமே ஃபிடே. ஐ டோன்ட் அண்டர்ஸ்டாண்ட் திஸ். ஆலமரத்துக்கு கீழே ஒரு பஞ்சாயத்தில் உட்காந்து ஒரு 4 பேர் கான்ஃபிடென்ஷியாலிட்டிலாம் ப்ரீச்சே, காஸ்ட் எஃபெக்டிவ் நானே பொட்டன்ஷியல்னு போட்டுட்டேன். டி ராஜேந்தர் கோட்ஸிங், ஸ்பேஸ் எக்ஸ் இலான் மஸ்க். எனிபடி ஹர்ட் அபவுட் டிஃபனி ப்ளூ? டிங் டிங் டிடிங். அது எனக்கு தெரியும், ஏன்னா நான் தான் பண்ணேன். திஸ் ப்ளீஸ் டேக் இட் as a தாரக மந்திரம் which will help you in achieving a lot of things. Happy, sleepy faces all around. Unfortunately, you are going to hear an advocate talk about law. Worst thing you can ever come across on a Saturday morning. But I'll try to make it as interesting as possible, because here we are in a congregation of budding entrepreneurs who have a kernel of an idea and they want to develop on it. And when intelligent people like you come out with a business solution, so whenever you guys come into the business arena with an idea, now that idea will have a force to push you forwards in the business field. When you move forward in a business field, you should always keep one eye behind you whenever it comes to things concerning legal, things concerning laws, things concerning rules, things concerning processes that guide you towards achieving what you want to achieve in the future. Now, when you talk about these processes and these legal compliances and all those, the very first thing that you might have to think about in that aspect is to have your relationships with your fellow business people within a 4 corners of what we call an understanding. Now, when we call a relationship based on an understanding, it can be from a trust point of view. You just have to give a handshake and get it done with. Boss, I have A, B, C, I will do it. And then the other person will say, I will give you D, E, F. Shake hands. Matter ends there. Now, had it been so simple, we would all be Elon Musks now. But unfortunately or fortunately, that is not the case here. So what you need to have is a structured format, a structured 4 corners, which will put whatever that you need to do as in the part of your obligations, and whatever the other party has to do as far as their obligations are concerned. What is the scope of services or the business that you provide? What is the consideration that you get from him? All these things, and most importantly, a contract has to necessarily involve a fallback clause, which will be what happens when the payment is not done, what happens when the work is not done, what happens when there is a delay, what happens when there is a complete breach of the understanding, and what will be the recourse if these things happen. Now, these are the essentials that needs to be covered in any understanding, formal or informal. Any understanding has to have all these aspects. But to have these kind of processes set in an informal format is a bane unto its own. You are entering into a pit without knowing its depth, which is always not a good thing whenever a person who wants to grow in the business to go under. So therefore, contracts form an essential part when it comes to a success of your business. As simple as that. Now, when I talk about startups, Tamil Nadu has one of the highest startup community, or rather highest number of startups growing. As of today, I think about 1,500 tech startups alone are there in Chennai itself. That is the kind of environment that we are growing in. That is the environment, that is the kind of a peer group that you are all falling under. Therefore, everybody will require that hand holding when it comes to properly going about your business and achieving that success. So that is where the contracts come in. So just to give you a brief outlook, so startups thrive on business relationships, right? And you will have various stakeholders like your suppliers, partners, investors, employees, customers. All these points are essentially to be governed by an agreement or a contract, in whichever way you call it. These relationships involves exchange of value, resources and intellectual property. I'll come to that last part, the intellectual property part, later. Misunderstandings, disputes, and even business failure could be caused due to the lack of clarity and formal agreement. Now, formal agreement is why contract comes into picture, and there has to be an absolute unambiguity and clarity in that. And contracts ensure mutual understanding and protection. So before going into what has to be done and what not to be done in respect of any contract, you need to understand what is a contract per se. Now, Contract Act of 1872, which has been there since 1872, is holding perfectly good as far as even the current contracts, even online contracts. So when you break it down to a micro level, contracts have these 7 issues, 7 things which have to be essentially covered. There has to be an offer. That is, a person who has something to give has to offer to give that something to the other person. And the second thing, most importantly, is that it has to have an acceptance on the other part. So when there is an offer and there should be an acceptance, then comes the most important part, which is the consideration. Consideration can be any kind. It can be payment in terms of money. It can be a mutual quid pro quo, as in I do this, you do that in return. It can be like that. So, but there has to be some kind of a consideration. Which consideration drives you to give that business to the other person. Then there has to be an intention to create legal relations, and capacity of parties. Capacity of parties is very important, because when it comes to somebody entering into a contract, you need to be assured that the person who is entering into a contract can actually get into that contract. For example, you are entering into a contract with a big concern, and a person, obviously when a company is signing a contract, the company is not going to sign the contract. Company is just a legal juristic person. It is not a person with physical attributes like we are. Therefore, when a company is being represented, or even a person is being represented by somebody else, you need to understand and be assured that the person who is signing on behalf of the company or the other person has the capacity to do so. For example, you need to ask them for an authorization. You need to ask them whether your board has confirmed that you are actually authorized to sign it on behalf of the company. For example, if there is a person who is on the other side and that person is giving an authorization to the other person in the form of, let us say, a power of attorney, you need to have a look at that document. You need to understand whether that document provides enough power or authorization to the person who is signing it on their behalf. So that is what capacity of parties is all about. And then lawful object. It's related to the offer and acceptance, because that offer and acceptance should be for a lawful purpose, not to, let us say, murder somebody, or like, it's an example. You can enter into a contract for anything. You can enter into a contract to have somebody beat somebody up. You can enter into a contract to have somebody's intellectual property taken away from them. Thievery of intellectual property. Those are also contracts, but since they don't fall under the ambit of lawful object, when the object of the contract is something that is not lawful, then also the contract fails. And free consent. Now, free consent is where startups will have to be very, very careful, because I'll come to that later also. I'll explain it more detail. Free consent is very essential, because when a startup like you are entering into a business arrangement with somebody else, and that somebody else, like Radha pointed out, is a 100 or 75-year-old company, an old establishment, they will have a set pattern, and they will have what we call a standard form of contract. For a particular purpose, you will be given a sheet of paper which will have very tiny font. You will not be able to even read it properly, and you will be asked to sign on dotted lines. Simply, it is not a figure of speech. You will be simply asked to sign on top of there will be an underline, and you will be asked to sign on top of it. That's it. Matter ends there. There will be no negotiations whatsoever. You should never get into a contract, if you can. I am putting the caveat also. If you can, you should never get into a contract where you don't have any chance or choice or an option to negotiate at all. That is where free consent comes in. Whenever you give consent, that is, there is an offer and there is an acceptance. Whenever you are giving that acceptance, you should give that acceptance freely, voluntarily from your heart, and after going through the processes in your head. That is what free consent is, and free consent is very, very important when it comes to startups like you guys. Now, why is contract essential? See, the points are very general. There is a clarity and mutual understanding whenever you get into any contract. You don't leave anything up in the air. You don't leave anything to the trust. You don't leave anything for the belief of the other person. Like when you say ABC, the other person has to understand that as ABC. The other person cannot understand it as DEF, or you cannot think that the other person might understand it as DEF, though you said ABC. Therefore, whenever you get into any contract, the terms are very clear. They have to be very clear, and there has to be a clear understanding of what you want to tell the other person. Risk mitigation, that is the end line of any contract. You are avoiding a risk. I will come to that, what risks you are avoiding later. But any contract, you are setting up 4 corners for a particular relationship. You are trying to militate it as much as possible so that there is no risk or less risk. Because I will also come to that, no contract is waterproof. No contract is foolproof. What we as advocates or we as drafters think is, we act as a devil's advocate for you, try to understand what are the pitfalls that you will be facing at a later point of time, what are the chances of this thing going to hit the fan, and then try to come up with solutions so that you don't get into that scenario. Therefore, risk mitigation is very important. That will be covered in the contract. Establishing payment terms. Consideration is what I mentioned previously. Consideration part is being covered here. The payment terms should be established in a very clear and categorical manner. If a payment has to be done, let us say in 10 days of receipt of the invoice, it has to be specifically mentioned there. Defining confidentiality. Now, defining confidentiality goes hand in hand with protecting intellectual property. See, whenever, as I started my talk, you startups come up with a kernel of idea. And the kernel of idea is that which is pushing you towards achieving something. And that kernel of idea will have to be new, novel, inventive for you guys to make a name in the business itself. Because if you are coming with something that is already being done by XYZ, you as a startup will not have any USP. There has to be an ultimate selling pointer which you guys will come up with, and that will be at some level considered to be your intellectual property. I will tell you how they are defined. That's on a whole different segment. But whatever comes out of your mind, that is not in the current state of affairs, that will be considered as an intellectual property. We will come to as to what kind of intellectual property it falls under, how to protect, that is on a different footing. So whenever you have an intellectual property and your startup is dependent on that, then comes the issue of defining the confidentiality. Because you are entering into an agreement with another party, and that party will be eagerly awaiting to know what you are coming out with in the business world. When that is an intellectual property of yours, there is every possibility of that intellectual property being grabbed and used by that other party. Therefore, you are putting in the processes there, systems and processes there to ensure that whatever you are divulging to the other party when you are entering into a contract will have to be kept confidential, and that has to be specifically worded. You can't just leave up in the air as to what can be considered confidential and what cannot be. I will come to that later. Then performance standards. Setting performance standards, attracting investment. Now, attracting investment is the end result, because when you have your systems and processes in place, investors will love to come and invest in you because you have all the safeguards ready. And the investors will also understand that you have all these safeguards ready, therefore their investment will be taken care of. Setting performance standards is also related to establishing payment terms, because you need to understand the scope of your work. You need to make the other party understand your scope of your work. What you can do, what you cannot do, what you will do, what you will not do. They are completely different. What you can do is different from what you will do. I can work till 12 o'clock in the night, but I won't is different. I can't leave my family and life for the purpose of a business is something that I won't do. So as an example, I'm giving you all this, but you will have to set the terms as to what can be given by you and what can the other party expect from you. That has to be very clearly delineated. And the last one is providing legal recourse. Providing legal recourse is when you set 1, 2, 3, 4, 5 and 6 of these arenas in place, what if there is a breach by the other party? What is the recourse for you when the other party breaches it? Or what is the recourse for the other party when you breach it? These have to be also very clearly defined in the contract. That is why a contract is very, very essential, because it delineates all these issues and it gives nothing to the imagination, gives everything on the paper. Now comes the most important part, which is what to agree on. See, scope of work or services, you need to very clearly delineate what is the scope of work, what do you bring on the table, how do you do it. All these things will have to be very clearly defined. The second one is what do you deliver. Your deliverables will have to be will not only be properly explained, but it will also be giving the timeline, the manner in which the deliverables are given to the other party, payment terms. Then I'll come to intellectual property rights will also have to be delineated, and confidentiality. They go hand in hand. Then the next important thing is termination clauses. Now, termination clause is very important because that is when you can legally pull out of an agreement. On what basis can you pull out of the agreement is being addressed by the termination clauses. For example, the other party delays the payment, for example, and you have already set a payment terms in the contract, and you should also set in what will be the recourse for you if there is a delay. For example, if there is a delay and the contract says you can give a notice to them for 10 days, expect them to make the payment by the end of the 10 days. If they don't make the payment, then you can terminate the agreement. If they have to give a deliverable on a certain day and they don't give a deliverable on a certain day, then you can opt out of the agreement. So these are the termination clauses, and apart from these eventual scenarios, you can also have a termination clause for a specified period of time. Like for example, you as a startup now will be entering into an agreement for, let us say, 2 years. As an advocate, as a legal practitioner, to advise a startup, I will always say have the term of the contract as small as possible. Because see, right now you are a startup, you will be working on a very razor thin profit margin, and you will be entering into an agreement with another company who will be choosing you because of your razor thin profit margin. But tomorrow, by the end of the financial year, you will grow and you will be in a better position of bargain. So if you lock yourself in, let us say, a high term contract, what we call as a long term contract, for example, you will be locked in for the same price points, same deliverables, same scope of work for, let us say, 5 years. You will be hit very hard if you get locked in. Because of that, you will not be able to maintain your price points, you will not be able to maintain your profit margin in the business, and you won't be able to grow. So my advice will always be, whenever it comes to termination clauses, whenever it comes to term of the contract, keep it as short as possible. Like let us say 1 year, 18 months, 2 years. Keep it as short as possible so that you get out of it, and then you have a better bargaining power for getting into the same agreement or with some other company. See, there are a number of companies and you will be entering into a contract, you will be constantly doing business, churning up business. So keep it as short as possible so that it becomes easy for you. Then liability and indemnification, that is very important, because liability and indemnification will go hand in hand with all the other points. See, whenever, for example, let us take confidentiality. Whenever there is a breach of confidentiality and the other party for some reason has given your the confidential information outside and you are facing some issues because of that. Indemnity is a concept under the contract law by which whenever you do a thing and the other party is affected because of that thing, which is also forming part of the contract, in that case the party who is affected will have to be compensated by the party through whom the issue has happened. So when I come back to the example that I started giving you, when there is a confidentiality clause and that confidentiality clause is breached by the other party, let us say by divulging it to a third party, and because of that you are in some way facing a loss in your business, then the other party should make good of the loss that you are facing in this business, which is what indemnification is all about. This is very important for startups because you are already entering into a bargain, or you're already entering into a business arrangement on a very thin margin and very thin profit point. And over and above that, when you are pushed to face some loss because of the fault done by the other party, you should be having an indemnity clause so that the other party indemnifies you, makes good of that loss, so that it pushes down your financial constraint, it pushes down your financial liability. And then governing law and jurisdiction, that is concerning the legal recourse. So whenever let us say you in Chennai or in Coimbatore are entering into an agreement with a company, let us say from outside Tamil Nadu, let us say Bangalore, let us say Hyderabad, try to see, as far if it is within the country, governing law should not be a problem, because governing law is something that is, as far as India is concerned, it's the same. Law is the same. Even if you are in Mumbai, you are in Delhi, Jammu, even now Jammu and Kashmir also has lost the special privilege. So even Jammu and Kashmir, it is the same law. But jurisdiction is very important, because that is where you will be losing a lot of money, because whenever you are entering into a legal dispute with the other party and you have to travel to another place to handle that case, then as in where the jurisdiction goes out of your place of business, then there also you have a problem. So therefore jurisdiction is also a pain point that you have to be very careful about. Warranties and representations goes hand in hand with the deliverables. So whenever you agree on doing something, you also warrant that if I don't follow that, I will do this. That is what warranty is all about. And representations is what you are giving as far as the undertakings that you are giving in the contract. This is very important. What not to agree? Ambiguity, vague language. It can lead to different interpretations, and that will always be the pain point for dispute. Unrealistic and unachievable obligations. Never do that. As I said previously, what you will do, what you can do, both have to be defined in the contract. You can do various things, but whether you will do is also very important. You will have to address both of those, especially when you are entering into an agreement with some big concerns, because those big concerns will expect a lot from you. But you will have to put your foot down and say, these are the things that I can achieve, these are the things that I will be willing to do for you, not more than that. So you can even negotiate on the payment terms based on that. One-sided indemnification clauses. As I said previously, indemnity has to be on both sides. If you do a mistake and the other party loses, the other party, you will have to make good of the loss to the other party. Most often than not, what happens is, whenever you enter into a contract with a big company, they will have one-sided indemnity clauses where it says that if I face a trouble because of you, boss, you will have to repay me. They will never talk about the flip side. You will have to ensure that the flip side is also being addressed too. An indemnity clause should always be double-sided. You should never say company will have to be indemnified by the startup. It should say a party who is facing a loss because of the issues faced by or an act done by the other party will have to indemnify the first party. It should be something very general. It should be both sides. It has to be addressing both sides. Excessive and unreasonable liability. See, liability, as I said previously, whenever you are representing something, you will have to stick to that representation, and when you don't stick to that representation, you will be liable for XYZ. Now that cannot be also one-sided like an indemnity clause. Okay, you as a big company expect me to do ABC, and if I don't, you have a liability clause against me. But what if you don't make a payment in time? An agreement which doesn't say or address that point is what is called excessive and unreasonable liability. You will have to address that. You will have to put your foot down, say no, it has to be both sides. Then unclear intellectual property transfer. Yes, this is very important, because see, whenever you are getting into an agreement and you have as your capital some intellectual property, let us say business model, let us say AI programming that will help in XYZ, let us say, giving you an example. Or you have some invention that you are giving to the other party for it to be marketed. In that way, when you are entering into an agreement, you should always make it very clear that this agreement does not in any way amount to transfer of the intellectual property. Whatever you are doing with my intellectual property is on a principle to principle basis, and you have a limited license. So whenever you ensure that that kind of a contract or that kind of terms are there in the agreement, that will enable you to retain the intellectual property, and those terms have to be very clear and unambiguous. When you are entering into an agreement, when you don't have a proper clause with regard to intellectual property, it will always lead to a trouble, because intellectual property is always a pain point, and the only recourse for you is to go to a suit, civil suit, go to a court, fight it out, win it. But if you have a contract or if you have a clause that addresses this point in the contract itself, when you get into the arrangement, it will save you a lot of money, one, and it will also help you to float in the business, which is very important. When you lose your intellectual property, more often than not, the startup will go down, because, as I said, you guys come with that particular idea, and when you don't properly protect that idea, then you would be put at a sea where you wouldn't know where to go further. That has to be addressed. Automatic renewal clauses with unfavorable terms. This also I addressed previously, because whenever you are getting into an agreement, it has to be as short as possible for a term is concerned, and the renewal clauses should be avoided. Automatic renewal clauses should always be avoided, because as a long-term contract, automatic renewal clause will also put you in a disadvantageous position, because you wouldn't be able to renegotiate the terms. Automatic renewal means the same agreement with the same price point, same deliverable, everything will be continuing for the next 4 years or 5 years or 10 years or whatever it is. So that has to be avoided. Lack of clear termination clause, here again, it should be, termination clauses should always address both sides. If you don't say, you don't do ABC, the other party has a right to termination. Similarly, when the other party does not do DEF, you should be in a position to terminate the agreement. Clauses which violate the local laws, see, this is a very rudimentary thing in any contract, because as I originally mentioned, with regard to the object of the contract should be legal. Whenever you are entering into an agreement with any company which is outside your territory, let us say you are entering into a company with having a business at Bangalore, you should understand. I'll give you a simple example. See, you are doing warehousing, right? Or rather, you are entering into an agreement with a company which is doing warehousing, right? You are into sale of products, or you are into logistics business. Okay, you are in a logistics business, the other party is doing warehousing. You should have a relationship, because for a logistics company, you cannot just like that take everything from here and land it there. You might have to protect the goods for a certain period of time, and you require warehousing facilities for that. When you are entering into a contract with a warehousing facility there, you have to understand the local laws pertaining to consignment transfer, the warehousing facility labor laws, all those things. You will have to understand all those things, and they should not be in violation of those local laws. That is very important. So for that, you will have to have a proper understanding of what the local laws of the particular area is concerned, and then tailor make your contract according to that. And of course, this, whenever you go to an advocate, they will try to do this. I don't. Overly complex and legalistic jargon, Latin words எல்லாம் போட்டு quid pro quo, அப்புறம் அந்த யுபிஜஸ் இபி ரெமிடியம், உபரிமே ஃபிடே, எல்லாத்துக்கும் மீனிங் இருக்குது. ஐம் நாட் சேயிங் they are not gibberish, but try to avoid those overly legalistic jargons. See, I'll tell you why this happens, because most lawyers think, as I said, as a devil's advocate, and they will also parallelly, since they are all, most of them, when you go to a practicing advocate na கோர்ட்டுக்கு போய் ப்ராக்டிஸ் பண்ணுற அட்வொகேட்ஸ் கிட்ட போனீங்கன்னா, they will also parallelly have in the back of their mind what or how they will present this, whenever this case comes to a court, how they will present this case to the judge. So when you think in that aspect, automatically sometimes what happens is, whatever we try to put across in the court, they might subconsciously come into the contracts. So wherever an advocate who whenever you go to an advocate for a contract drafting and the advocate comes up with some overly complex things, some legalistic jargons, please go back to the advocate saying, boss, I understand you are very clever, but please remove all these things. I don't understand this. Why? Because you are a business person. The other person who is entering into a contract with you is also a business person. They don't necessarily have to know all these things. So in that scenario, when you have to have this unambiguous and when you want to avoid ambiguous and vague language, you should also avoid overly complex and legalistic jargons. So now comes the mandatory clauses. I have given you an idea as to what has to be there and what not to be there. These are general things. Now, most specifically for startups, most specifically for budding entrepreneurs, these are the most important clauses that you need to cover. You need to necessarily have an intellectual property right clause. You need to define what you are giving, how you are giving, on what basis you are giving your intellectual property. Be it a trademark, be it a patented technology, be it a copyrighted artistic work, or let us say a programming, computer programming. All these things will be covered, your designs, all these things will be covered under intellectual property rights. As I said, confidentiality clauses should be definitely there, right? And then limitation of liability clauses. You need to give proper delineation of your deliverables and you need to limit your liability only to that. As I said, indemnity clauses should always be both sided. They should never be one-sided. Termination for cause. Any specific scenarios that you anticipate might happen which might not enable you to continue your relationship with the other company, you should put it across and put it in the termination for a cause. Payment terms, and then the governing law and arbitration, jurisdiction clauses. They should always be, as I said, favorable to you. So when you are in, let us say you are in Chennai or Coimbatore, and you want to put in a governing law and a jurisdiction clause, jurisdiction clause when it comes to you, you should always ensure that you retain the jurisdiction with your area. Let us say if it is in Chennai, put it very clearly, courts in Chennai will have the jurisdiction to take up any matters with regard to disputes arising out of this agreement. Whenever you go outside the country, you enter into a contract with, let us say, a US company or a European company, then you try to ensure that the governing law should always be Indian laws. You can have your jurisdiction, and as far as arbitration is concerned, you can have it elsewhere also. Like for example, whenever I enter into a contract, when I draft a contract for a concern between, draft a contract between a US company and an Indian company, I will always ensure that the place in which arbitration the arbitration has to be in a place which is in between, let us say Dubai or Singapore. They are all well reputed and well known arbitration centers. We have in India also, but instead of them coming all the way, it's always a give and take, So அந்த மாதிரி இருக்கும்போது you try to put in a jurisdiction which is in India, but you can have an arbitration elsewhere also. So arbitration is something which is not new to India. It's been there for a very long time, but it has taken primacy in the recent days because of the booming commercial contracts within the country. See, any commercial arrangement, if it is governed by a contract, it is done between two persons or entities who want to abide by that particular written terms. Whenever there is a contract in place and you sign a contract and the other party also sign a contract, both of you sign the contract with an idea that you will go by whatever is written there. So in that case, when both sides use their common sense and want to proceed in the business arrangement based on the written words of the contract, then arbitration is a very important tool, because arbitration is a process in which two civilized entities sit across a table and decide the issues among themselves. When they are not able to sit across the table and decide it among themselves, they will appoint a third person and they will repose confidence on that third person to do it on their behalf. ரெண்டு பேர் இருக்காங்க. முன்ன காலத்துலலாம் we had panchayat systems and all. ஆலமரத்துக்கு கீழே ஒரு பஞ்சாயத்தில் உட்காந்து ஒரு 4 பேர், that those 4 people will not have any idea as to what law is, what legal process is, what has to be done if one thing happens or other. They won't have all these legal knowledge, but they will have a sense of right, sense of justice, sense of what has to be done to bring an ailing party from that ailment. Only that is there, and the moral compass nu solrom paringla, and the moral compass will be there. That is the only thing based on which they will be giving out their ruling. And If you have to go to a panchayat, for example, both parties will have to agree to go to the panchayat. So when you want to give a pradu to the panchayat, the other party will have to confirm that yes, இந்த மாதிரி ஒரு issue இருக்கு, நீங்கள் டிசைட் பண்ணி சொல்லுங்கள். This exactly is what arbitration is all about. Arbitration it is not something that is coming out of the thin air, it is not falling from the sky. It is very basic thing that we have all at least seen in the movies as to panchayat system. You enter into an agreement with the other person and you want to you encounter a dispute with the other person and you want to resolve that dispute in a very amicable way. You go for an arbitration. Before going for an arbitration, you put that arbitration clause in the agreement itself, and you also delineate as to how that arbitration has to go. Like if you want a single arbitrator or if you want a mutual arbitrator who will have an umpire in between, you can have all these things delineated, where the arbitration will sit, how the arbitration will be proceeded with. There is something called an Arbitration and Conciliation Act act that has been formulated in India. So whatever process that the arbitrator has to follow to come out with a resolution for the dispute, they will follow the Arbitration Act. All these things you can put it in the agreement itself. Now what are the advantages of arbitration is here. You have a faster resolution. Ideally an arbitration is informal. Therefore you are not bogged with the processes of a legal court, law court. You don't have the evidence, இப்படி தான் இருக்கணும், இப்படி தான் நீங்கள் வந்து எவிடன்ஸ் கொடுக்கணும், இந்த மாதிரி ஒரு வாய்தா ஆக வேண்டிய அவசியம் கிடையாது. You file a case today and you will have to follow certain procedures for the case to be numbered, and then follow certain procedures for the other side to come, follow certain procedures for the other side to file something, follow certain procedures to go for trial, follow certain procedures how the trial is going on. And then at the end of the day, when you come for the final arguments, final decision before the court, you will be facing, you will be 5 years or 10 years down the line. So that can be avoided through arbitration, because whenever you go for an arbitration, on day one you will fix the timetable. A will give his claim on this day, B will file a reply to the claim on this day. Both of you will be filing evidence along with your claims. And then if A has something to respond to the reply, it will be done on a certain day. And then the tribunal will sit, arbitrator will sit on a particular day, frame up the issue. Issue அப்படிங்கிறது என்னன்னா, it is the dispute that you are coming across. I have A, B, C. These are the things that I want resolution for. அப்படின்னா those are the issues that will be framed by the arbitrator. Then straight away it goes for arguments. I will say my side of the argument, the other side will say his side of the argument. I will give my reply, that's all. So it is as informal as possible, it is as cozy as possible. It can be just like that had in a conference hall. So faster resolution is always there. And the most important thing is confidentiality. Whatever you speak before the arbitrator will be only before the arbitrator. But on the other hand, if you, for example, go to a court and you file a document in the court, any person by filing an application can try to take a copy of whatever you have filed in the court. So confidentiality is maintained. So whenever there is a, let us say, breach of confidentiality issue and that goes to an arbitration, confidentiality எல்லாம் breach, அதுவே கோர்ட்டுக்கு போகும்போது it will be open, right? That is avoided here. And then expertise. See, for example, you have let us say two concerns having architectural firms இருக்கு, இல்லை ஏதாவது ஒரு கம்ப்யூட்டர் கம்பெனிஸ் இருக்குது. Those computer companies have a dispute and dispute is with regard to deliverables on a particular software அப்படின்னா, if you go to a court, the judge might not have, the judge will be learned, he will be experienced, but he will be learned and experienced in law. He will know இந்த ப்ராசஸுக்கு இப்படி தான் லாவில் சொல்லியிருக்காங்க அப்படின்னு மட்டும்தான் அவருக்கு தெரியுமே ஒழிய, இந்த கம்ப்யூட்டர் டெலிவரபிளுக்கு இந்த மாதிரி எப்படி புரிஞ்சுட்டு எப்படி அதுக்கான சொல்யூஷன் கொடுக்கறதுங்கிறது he might not know. Very rare that you find a judge who is also an expert in a particular field on which you are giving on which you are filing a case. But when it comes to arbitration, you can pick and choose between the two parties. You can pick and choose who you want to arbitrate. So for example, any neutral party, you are a company, you both are having a dispute with regard to one particular aspect. and you want to go for an arbitration அப்படின்னா, you can go to that gentleman who might also be in the same field, who will be in the know of things, and who will be in a better position to give a resolution in a dispute. That is very important, because whenever you go for a relief oriented aspect na, you want a person who understands what you are going through, and you want a person who can give a proper resolution for what you are going through. That is very important. That expertise is available in an arbitration. And cost effective naane potential nu potutten, because arbitration is never cheap. The courts are cheap whenever it comes to filing a case is concerned. You end up paying about like 3% of whatever value of the suit is all about. But when it goes to arbitration la fees persa kedaiyadhu. But when you appoint an arbitrator, he will fix a fee. It used to be even worse. Arbitrator will fix a fee based on the value that he perceives of the claim. But now there is a amendment to the Arbitration and Conciliation Act which has a schedule which says if the value is so and so, you will have to pay so and so. So there is a delineation how fees has to be paid அப்படிங்கிறதெல்லாம் வந்துட்டு. So it has effectively come on a cost effective basis, but still you will have to shell out some money. That is always there. வேற வழியே கிடையாது. And then flexibility, as I said, faster resolution இருக்கிறதுனால, since it is informal, it is also slightly flexible, and it is less adversarial. So when I say less adversarial, you need to think it in the form of T. Rajendra court scene. அடுக்குமொழியில் பேசிட்டு, I don't know if how many of you know about that. There is a particular movie, பேர் கூட மறந்து போச்சு எனக்கு. There is a particular movie where T. Rajendra will be on one side, Gautami will be on the other side. You will not be able to follow what the case is about. You will only be listening to what T. Rajendra talks about. அடுக்குமொழியில் அப்படியே பேசிட்டே போவார். That is there. I am not joking. It is there in court, because people tend to show their flow. They tend to show their knowledge, as in the advocates. I am talking about advocates. They tend to show their knowledge. They tend to show their understanding of the law more than the other side. Therefore, there will always be a tussle. அந்த டசலில் உங்கள் இஷ்யூ கீழே போயிடும். ரைட்? ஐ எம் நாட் சேயிங் இன் ஆல் த கேசஸ், பட் it happens. And arbitration tries to avoid that, because in arbitration, ideally, you don't have to go for an advocate at all. You will have to go for an advocate for the purpose of drafting it, but you have the choice of arguing it yourself, because at the end of the day, you will be the person who will be best able to articulate your issues, and whenever those issues pertain to a particular field, and then you are an expert in that field, and then you are also talking to an expert in the field அப்படின்னா, it is easier for you to talk to the arbitrator explaining your case, and it is also easy for the other side also to talk themselves to the the arbitrator, and then the arbitrator comes out with a resolution. You don't have to go for an advocate, but more often than not, people do go for an advocate, because arbitration also has slowly transformed into a regular court proceeding. பண்ணிட்டாங்க. Enforceability, that is the most important thing, because இந்த மாதிரி ஒருத்தர்கிட்ட போகிறோமே நம்ம, அவர் சொன்னால் வந்து கேட்பாங்களா அதர் சைடு? கன்சென்ட்டோட தான் வராங்க, இருந்தாலும் பிரச்சனை இருக்கும். இருந்தாலும் the other side will have something to say against that person's decision, final decision. What if the other person does not agree with the final decision of the arbitrator அப்படின்னா, that is when the Arbitration Act also again comes into the picture, saying whenever an arbitrator who is appointed on the basis of consent of both parties gives an award, that award will be equivalent to a decree of a civil suit. So therefore, when an award comes, you can automatically go to any civil court to execute that award. I'll tell you what the award is and what execution is all about. See, whenever a civil court comes to a decision, the decision is called the judgment. It will have the reasons as to why a particular judge comes out with that particular decision. And then the court will also give a direction to the party who has lost to do ABC. For example, you file a civil suit against another person for recovery of money. You won the civil suit. The judge will write a detailed judgment explaining why he has decided that the person who filed the suit has to get the money back. That is the judgment. And then he will also write something called a decree. Now the decree is having the direction to the other person to do ABC. Boss, This is the judgment. This is I've held that the other person has to get the money. You pay the money. Now that you pay the money, அப்படிங்கிற அந்த part வந்து that is called a direction, that is called a decree. That document which has that direction is called a decree, and that decree will have an enforcement through an execution code. For example, the person who has gotten a decree against him from the court directing him to pay money to another person, and the person doesn't obey the decree, then what you can do, the next recourse for you is to go for an execution of the decree. Execution of the decree will again be before the same court which gave the order, or within the jurisdictional court which gave the order, either way. And that court will once again go through the decree. It won't reanalyze the matter. It will go through the decree. It will ask the other person to come, boss, this is the decree, why don't you follow? And if the other person doesn't follow it, even then the court, the civil court which executes the decree, can go against his property, sell his property, get the money back, give it to him. That is what an execution is all about. Execution proceeding. An arbitration, whenever it gives an award, straight away you go, அந்த ஒரு இந்த காமெடியில் வருமே, 1லேருந்து 16 கேள்வி வந்தால் 16வது கேள்விக்கு முடிச்சிங்கன்னா 1 கோடி, நான் நேராக 16வது கேள்விக்கே போகிறேன். ஆர்பிட்ரேஷன் takes you straight to the 16வது கேள்வி. You go to that, immediately you ask the other person to pay. If the other person doesn't pay, immediately go to the execution court, get the decree executed. So that enforceability is also there. So these are the advantages of an arbitration clause. It streamlines the dispute. Now comes the most important part of protecting your intellectual property. So I have till now discussed about what contracts are all about, how can you protect your interests in a contract. Intellectual property அப்படின்னு சொல்லும்போது there is mainly, I'm not saying only these, there are mainly 3 intellectual properties that are very important and they have to be protected. There are actually 4, but I'll minimize it to 3. One is trademarks. What is a trademark? A trademark is something that connects you with whatever you are giving out in the form of a deliverable, your product, your service, whatever it is. Trademark does the job of connecting the product or the service with you as a company. So it is called a source indicator. Whenever you go to a provision stores, you see n number of products there. You only look at the mark or the brand that is there in the product, and then over a period of time, through your association from over a period of time, what you think is this product is coming from this company. Sampan அப்படின்னு ஒன்று இருக்குது. எவ்வளோ பேருக்கு சமைப்பீங்கன்னு எனக்கு தெரியல, நான் கொஞ்சம் பண்ணுவேன் அதனால சொல்கிறேன். சம்பன் அப்படின்னு ஒரு இது இருக்குது. சம்பன் அப்படிங்கிறது வந்து இட் இஸ் something related to your dal, your cooking items, all those things. That is a trademark of Tata. Ashirvad, what comes to your mind? ஆஷிர்வாதோட சோர்ஸ் என்ன? ஐடிசினா என்ன? இவ்வளோ தான் சார் பிராண்டு, இவ்வளோ தான் சார் ட்ரேட்மார்க். ஸ்பேஸ் எக்ஸ்னா என்ன? இலான் மஸ்க். ஸ்பேஸ் எக்ஸ், இலான் மஸ்க். ஐடிசி, tobacco company. Ashirvad also belongs to ITC. See, this connection that happens to you when you look at a particular thing. I'm not saying words. Please understand me, I'm saying a thing. Anything that connects that product with the particular brand or a particular owner or the origin will be considered as a trademark. So trademark need not exclusively be only words. Trademarks can also be a logo. Trademarks can also be, these days there are new things called unconventional trademarks. A smell can be a trademark. A color can be a trademark. A smell can be a trademark. Perfume smells. Color can be a trademark. Sound can be a trademark. Color ku oru example kudukanona, there are to my knowledge there are about 5 or 7 color trademarks that are there. Anybody heard about Tiffany blue? There is a specific azure blue that is associated only with a company called Tiffany's. பயங்கர பாஷான கம்பெனி. UPS brown. UPS brown is trademarked. நமக்கு தெரிஞ்சது சொல்கிறேன். Cadbury purple is a trademark. They tried to do it, but அது என்ன ஸ்டேஜில் இருக்குன்னு தெரியல. They tried to do it. Cadbury purple. These are called unconventional trademarks. Sound is a trademark. Ting ting tiding. What comes to your mind? Ting ting tiding. Britannia. Dun dun dunzo. Dunzo. அது எனக்கு தெரியும், ஏன்னா நான் தான் பண்ணேன். So sounds can also be trademarked. So basically anything that can connect a particular product or a service with the source from which the service or product comes in can be a trademark. And a trademark is something that gives you an exclusive right. And with that exclusive right, it allows you to take action against third parties who are infringing that particular right. And it gives you a brand recognition. And when you have a registration, let us say, or even you have applied for a trademark, when you go to investors, it gives them that push towards investing in your company, because they understand that you are valuing your intellectual property and you are trying to protect that intellectual property. Therefore their investment might not go waste. So that gives you that investment, it helps you. And then of course legal recourse is there. Whenever somebody is using your trademark, you can go against them, you can file a civil suit. You can trademark arbitrability of a trademark is still up in the air. It is not decided yet, but trademark can be protected through a civil suit. That can be done. And when you are registered, you are in a more advantageous position, because courts will prima facie conclude that, first impressions, it will conclude that yes, you are the owner of the trademark, you have a protection, and your protection is lasted for this many number of years. So recognition or registration gives you that kind of an advantage. And then there is also licensing opportunities. So when you are let us say a big you have developed and you have multiple products and you have multiple brandings, and you have a bandwidth to, let us say, do 4 products, and you have more than 4 brands, but you can do manufacture 4 brands. You can license it to a third party for the purpose of manufacturing it for you. Their manufacturing and their use of the mark will also inure to you. It is not that simply because you have given a license to the other party will start taking advantage of it. No. There again the contract comes into place. There again you will have to delineate what your intellectual property clause is all about, and then you will end up taking the benefit out of their use of the intellectual property, the trademark. And the next most important trademark is patenting. I'll come to copyright a bit later. Trademark, the patenting is there. Patenting is something that protects your innovations. Whenever you have something new, something novel, something inventive that is not already there in the existing state of things, then you can, for that technological input that you bring in, you will be given a monopoly for 20 years. And that monopoly will give you the 20 years of exclusive use. அந்த 20 வருஷம் நீங்கள் மட்டும்தான் யூஸ் பண்ண முடியும். Once the 20 years lapses, then it goes to the public domain and everybody can start using it. So it will give you a huge head start of 20 years for you to use that patented technology. Think about the head start that you get from using that patented technology for 20 years when you don't have any competitor in the same technology. That's the power of a patent. And it is something that the government gives. When you can explain few things, as in how do you think that it is novel, how do you think that it is something that is not there in the existing technology, what are your claims in the respect of that particular technology. When you give all these details, it's even more than that, but I'm giving you a very general idea. When you give all these things, the government looks at it. The government has a patent office which looks at it and then grants you a patent, which patent will give you a 20-year head start of monopoly, which will help you in achieving a lot of things. And the next most important thing is copyright. Copyright is as general as possible, sir. Anything that comes out of your mind, when it is written down or even typed out, which is called expressing it, you have to express your idea. When you express your idea, trademark vidunga, patent vidunga. When you express your idea in the form of writing, you are given copyright. Anything can be copyrighted, quite literally. You draw a line, it can be copyrighted, but whether you will be able to protect it is dependent on the content of the copyright, right? And there again you have ownership, legal recourse, licensing opportunities, all those things are there. See, as far as patenting is concerned, I will give you one more advantage. I have written it down. It gives you a technological advantage, it allows you to build a technological barrier. What do you mean by technological barrier? It makes it difficult for competitors to enter the market with similar product or processes. So when you have that monopoly and somebody else comes in with the same product or same technology, you can effectively put them to a full stop with your patented technology. So that's a big advantage for a startup, because that will give you an edge over your competitors. That's about the intellectual property rights. This, please take it as a Taraka Mandram. Contract is not an expense. You will be shelling out money to build a contract, but it is not. Don't consider it as an expense. It is an investment that helps you reap a lot of profits at a later point of time. You will be, all of those profits at this point of time when you're drafting a contract will be a hidden entity. But you will be shelling out if you don't have a contract, you'll be shelling out a lot of time in trying to understand what the other party says. You will be shelling out a lot of money in legal issues, courts, advocates, arbitrations, all these things. When you have a proper contract in form, in form and manner, in a particular prescribed method, you can prevent a lot of losses, and you should consider it as an investment for the future. Apart from this Taraka Mandram, I have one keyword: invest, seek, protect. Invest in legal foundations for a strong, sustainable future. Seek legal counsel to draft and review all your contracts. Protect your intellectual properties and actively assert such protection when necessary. If you follow these, யாராலையும் உங்களை ஸ்டாப் பண்ண முடியாது. Simply put, that's it. Thank you.